Good afternoon. My name is Jennifer Carroll, and welcome to today's edition of Florida Appeals Journal. Today, we're going to talk about a very big change in Florida law, alimony. I think as many people now know, we're August 7th today. July 1st, the new law went into effect, getting rid of permanent alimony in the state of Florida. No more permanent alimony. Section 61.08 of Florida Statutes has been revamped. Senate Bill 1416 was signed into law, and the new bill went into effect July 1st of 2023, and it applies to all current and pending cases as of that date. Very important. So now in Florida, no longer do we have permanent alimony. What we have is still temporary. You've got bridge the gap, you've got rehabilitative, and you have durational alimony. And these forms can come in the form of either lump sum or periodic payments. And that's going to be left to the trial judge and based on the specifics of the case. Now, this bill codifies the law that the party seeking alimony has the burden of proof, right? Show need and then show the other party's ability to pay. The statute now codifies that to secure alimony with life insurance, there must be some type of special circumstances. So now you've got that actually written into the statute. The court now has to lay out findings of fact, not only for the type of alimony awarded, if any, but also findings of fact supporting the basis. So trial judges got to lay out the basis for the length of time of any award. Now, other factors that the court can consider, and let me just say factors, I refer you to the statute, but a few things the legislature added. One, I think that's very significant is, quote, anticipated need and necessities of life after the divorce. And that's in addition to the lifestyle of the parties during the marriage. And that's going to prove to be significant, I think a highly litigated factor. The court also has to look at mental health of the party. If mental health of a party is raised, whether that condition is permanent or temporary. Of course, whether a party can obtain education or skills to contribute to their own survival. And then adultery. They put this in the statute. By either party to the marriage and the resulting economic impact of that adultery. Now, the legislature also, and so what I'm trying to do is hit some of the key segments of the law that have changed, I think are going to really make a difference in family law, and certainly with respect to awards of alimony. The legislature has now provided alimony formula guidelines, so to speak, for the amount of alimony to be paid. And it used to be trial court had complete discretion over the amount to be paid out. Now the standard is any amount of alimony to be paid would need to be reasonable or not to exceed 35% of the difference between the net incomes of the parties, whichever is less. All right, so the net income is going to be defined by reference to section 61.30 sub 2 and sub 3, which is the statute governing how income is calculated for child support purposes. And so that will provide you with a detailed list of what can and can't be included as part of gross income. And that includes all forms of income, taxable and non-taxable. Now, you've got bridge the gap, rehabilitation, alimony. So bridge the gap, so that we're on the same page. Alimony is awarded to provide support to a party in making the transition. It's a transitory type of support from being married to being single. And the bridge the gap alimony assists the party with legitimate identifiable short-term needs. And the length of the award, and this is important, length of award of bridge the gap can't exceed 2 years. Rehabilitative alimony, that's really for purposes of redevelopment of a skill, previous skill or credentials, or the acquisition of training, education, work experience necessary to get the employment skills so that a spouse can become self-sufficient. The statute added length of time. The length of an award of rehabilitative alimony cannot exceed 5 years. So that's something new in the statute. So then it comes down to durational alimony, which I think that's where it's all going to be about now. That's what's really going to be the focus is durational alimony, and that will be what spouses will be seeking. That is a type of spousal support that provides financial assistance to the disadvantaged spouse, right, for a set period of time. That's why it's always hard to modify durational too, because it is for a given period of time, and so that does make it harder. And I think the law recognizes that too. So the factors, again, the court has to consider, again, laid out in the statute, but it's going to look at duration of the marriage, the parties' incomes, the parties' earning capacity, standard of living, and again, the anticipated needs and necessities of life of each party after the divorce. And the court can award more than one type of alimony, given the circumstances of a particular case. So in the statute, the legislature has now redefined length of marriage. Okay, so when you're dealing with durational alimony, it cannot exceed 50% of the length of a short-term marriage, 60% of the length of a moderate-term marriage, and 75% of the length of a long-term marriage. Now, there is, and with regards to payment of alimony, there is a rebuttable presumption that a marriage of less than 10 years is considered a short-term marriage. A marriage of between 10 to 20 years is considered a moderate-term marriage. And a marriage of 20 years or more will now be considered a long-term marriage. And that's all of this is a deviation from prior law, which they were a lot less. So can the court extend the length of durational alimony? Well, yes, it can. And it's under exceptional circumstances. That's why you always have to read the statute carefully, because it's always devil's in the detail, right? So the exceptional circumstances can include, first, the extent to which the recipient's age and employability limit the recipient's ability to become self-supporting. Two, the extent to which the recipient's financial resources limit the recipient's ability to be self-supporting. Three, the extent to which the recipient is mentally or physically disabled. That's going to be an important consideration. And four, the extent to which the recipient is the caregiver of a mentally or physically disabled child of the parties. So there are exceptions, and with exceptional circumstances, durational alimony can be extended beyond that formula. Now, similar to the other forms of alimony, Florida courts will allow the courts to consider so many factors, right, when determining how much of any durational alimony should be awarded. And we went over some of them. I want to make sure we've covered all, but always I just refer you to the statute. I think we talked about divorcing couples' standard of living, age of the spouse, physical and emotional condition of each spouse, earnings, education, and the non-economic contributions of each spouse, such as homemaking and childcare, and future financial prospects for each party. What I think is important in the statute, and I think it's very important not to overlook it, is at the beginning of the statute, it says, I want to make sure I get this, yes, on 61.08, 1. In a proceeding for dissolution of marriage, the court may grant alimony to either party in the form or forms of temporary, bridge the gap, rehabilitative, or durational alimony, as is equitable. That to me is very significant, because I think that gives the trial court a lot of discretion, and it gives a lot of room for the parties to make their case with respect to their individual client. So by them putting that in, codifying it in the statute, that they're crafting an equitable durational alimony award, but emphasis on equity. So that is going to be very significant in providing relief that may be needed to a particular spouse in your case. Remember, durational alimony, of course, runs until the end of the time period, the court-ordered expiration date. And courts can modify. Now, they can modify on a case-by-case basis, but some situations, and really there are three key ones where a court may allow for modification of durational alimony. And one, a substantial change in financial and personal circumstances. We all know that. Two, the receiving spouse is remarried or entered into a supportive relationship. And then three, the paying or the receiving spouse has died. So there will be subject to modification. And when we're talking about modification and actions for modification, the court will be authorized to terminate or reduce an award of alimony when the payer has reached the normal retirement age. So we didn't really have that clear in the statute before. I never really talked about the details with respect to retirement being a basis of consideration with respect to the paying or modification of payment of alimony. So what is normal retirement age? Statute defines that. So the normal retirement age will be considered, quote, to be the normal retirement age specified by the Social Security Administration or the customary retirement age for the payer's profession. So the payer, of course, must actually retire or make demonstrable efforts to retire, and they must be legitimate efforts, okay? And retirement must reduce the payer's ability to pay, of course. If he still has ability to pay, then still capable of making payment. So that, in a nutshell, there are some of the main changes in the recent legislation doing away with permanent alimony. But I think there's a lot there, I think, for the trial judges and for the parties and their attorneys to work with. Definitely, I think, in getting the right relief that they need under the circumstances of each case. We're going to also try to attach a statute and the staff analysis, the Senate staff analysis. I think it's for Senate Bill 1416, which I think is very helpful in understanding how all this came about. So again, thank you for joining us today. An exciting topic, a very, very significant topic in the state of Florida and probably in the country, setting a new standard. Any questions, by all means, please contact us and let us know. Thank you again, and we'll see you next time. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.